Okay. My name is Brad Gardner, and I'm a judge in this court. I'm not here to conduct a trial of your case or to take a plea in your case. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand. Do you swear or affirm any statements you make during this proceeding will be the truth, the whole truth, so help you God?
Yes.
Okay, let's start with Miss Hardy, Whitney Hardy.
Your Honor, and if the court will allow, after you finish, Miss Hardy, could we switch over to the male side just to do two? That's the medical, and go back to the females.
That's fine. I saw that there are some ones who are on top, so I was going to ask you about that. Thank you for reminding me. Miss Hardy, I would normally speak to you directly. However, you have a lawyer here, Mr. Brill. So I'm going to speak to Mr. Brill rather than speaking to you. Please be aware that any statements you make during this proceeding are not privileged. So don't say anything that you don't want the whole world to know. Okay? All right. Mr. Brill, I have preliminarily set bond in this case at $5,000 on the battery and $3,000 on the criminal trespass with the stay away provision for Yolanda Wilfork. But I understand that you want to address the court about your client and about bond.
That's correct, Your Honor, and I'd be proceeding to make a bond argument as to what we would certainly like the court to consider in terms of a bond amount and conditions. Judge, addressing, as you've already set bond, I'm not going to harp too hard on the Ayala factors. I would agree with the court that my client is a good candidate for bond. Today, we would be asking for proposing that my client would be also a good candidate for unsecured judicial release. This incident resulted from my client having a mental health episode. She has been diagnosed with schizoaffective disorder. Before this incident, she has had some arrests that kind of come from the mental health episodes, but there's been significant change since this incident happened. She was not actually arrested at the time. That's why she turned herself in yesterday. She was taken to Grady on a 1013 status, where following she received treatment at the Southern Center and Riverwoods in Clayton County. They have got her on a plan, and she did attend a mental health evaluation and treatment yesterday before she turned herself into the jail after she retained counsel. Miss Hardy is, she has 2 degrees. She works in marketing. And this mental health thing that is she's more stable now than certainly her mother's ever seen. The mother, Miss Wilfork, did attempt to contact the solicitor's office about these charges, but retained counsel after she could not get any traction. We've already spoken with the solicitor about these charges, and while they would not consent to an unsecured judicial release, they were not in opposition to bond. So we've already began a conversation in terms of seeing this resolution, but more importantly, I think for these issues, not to dismiss the significance of the crimes that are alleged, but to say that Ms. Hardy's mental health is her primary focus at this juncture, and she's already taken positive steps to make sure she continues to be, improving and dealing with the episodes that she has. She's not had an episode since the incident alleged. She's been medically compliant in terms of taking her medication. She went yesterday to the Riverwoods facility in Clayton to make sure that she had the proper medication, and she has an appointment on July the 13th and an appointment the following week with Kaiser Permanente Behavioral Health Services. We would be asking that for the unsecured release, and so that she is able to financially make sure that she continues to put her money down to make paying for those treatments and paying for insurance. In addition, her most stable residence would be with Miss Wilfork, who is on this call. Miss Wilfork was the one who reached out to me in the first place to see what we could do about this case. And I would proffer to the court and Miss Wilfork, if the judge would like to hear from her, she's willing to speak, but I would proffer that she's not in fear of any issues from the client or from my client. She certainly represents ties to the community, and she has no problem. And I think that any possible concern the court have would be assuaged by a no violent contact order as to a no contact order. We are afraid, Your Honor, that a no contact order would not endanger the client in terms of her housing situation, but I think her most secure housing situation in terms of falling for her mental health treatment going forward would be to remain in or be able to stay with her mother. Her mother does have power of attorney over the client. So, Judge, we'd be asking the court to consider an unsecured judicial release based on my client, turning herself in and retaining counsel and reaching out to solicitor to try and deal with this. And if the court would like to hear from Ms. Wilfork, she is present in court, but I will defer to the court if you need any more information.
I don't believe I need to hear from Ms. Wilfork unless she just really wants to make a statement. I mean, I will explain my decision. I'm not going to consider unsecured judicial release. I don't know if I could, based upon the allegation of this being a crime of violence. And if it is something that would be considered, my understanding is it would have to be the chief judge that would have to make that determination.
Understood, Your Honor. I understand the court's position on that. I think that in terms of the allegations, I'm not going to go further. I understand your position on that. I don't necessarily agree with it, but yes.
Yes, and I'll explain a little bit. My career, I'm still a criminal defense lawyer, and I've been doing death penalty cases for more than 15 years, handled more than 30 death penalty cases. And there are at least 6 or 7 that I know of where it was the child was mentally ill and killed or attacked a family member in the midst of a mental health episode, which is not a defense. And the person ends up looking at spending the rest of their life in prison, not because it's where they deserve to be, but because the crime generally is one of those things where it's like, oh my God, this person almost severed this person's head. They um, attacked every member in the family. I was looking at your client's criminal history, and all of her arrests have been crimes of violence. And I
And
understand that it's like, well, it happened in the middle of a mental health episode, but what happens if there's uh, a knife attack?
and Judge, I understand the court's concern. I think that in terms of this, the allegations specifically here, I think that the window and the pushing down, that was after, I think there was some difficulty between, but the incidents, as I recall, um, certainly my client did not, or my client's mother did not say that the incident of violence to the responding officer was intentional, or she was in fear of the violence continuing, that it
Right.
was in terms of her trying to leave the residence. That's my understanding of the incident report. So, and Judge, I completely understand your that experience. I've handled cases along similar lines. But what I would say is, and again, I think the bond that you set is certainly, it's not unreasonable. But we are concerned about the no contact provision, and Ms. Woolfolk does not have any issue with my client residing at the house. And I think that a no violent contact provision is more appropriate.
So what has been asked of us is that, especially when you're talking about family violence related situations, is that we place a no contact provision at the first appearance, so that either the district attorney's office or the solicitor's office will have an opportunity to look into the case and make their own independent determination. Because one of the things that the reason I was saying the issue before about not wanting to prosecute is I get that a lot at this stage, and I'll say, well, the first way to not prosecute is to not call the police. That once you call the police, you're putting other people into the situation, and they now have to make their own independent judgment. The police were called, the warrants were obtained, and so now I do hear what you're saying, and I'm not unsympathetic, but I'm gonna leave the stay away provision on until someone from the solicitor's office has an opportunity to look into this.
Well, and Your Honor, if I may, I have been in touch with the solicitor's office. The solicitor's office told me point blank that they won't look into it until my client turns herself in. The second thing is that they're not at first appearance, which that's their prerogative. But the third thing is, and I will ask Ms. Woolfolk to speak now. My concern for the client is because the victim in this case has power of attorney for her daughter. She assists her daughter in getting the mental health treatment that she needs. Having no contact is going to prohibit and probably place my client in a position that makes it more difficult for her to obtain the treatment that will prevent any issues going forward. Ms. Woolfolk, I'm going to ask Ms. Woolfolk to address the court. She is the victim and she has the right to address the court. And again, Judge, I am very sympathetic to the court's concerns here, but a no contact provision, I think, sets my client up for deep.
I do understand. I do understand. I mean, we've been pushing for a mental health court here in Clayton County. I do understand. And before Ms. Woolfolk speaks, I'll just use this. Let's look at it from the inverse. That if Ms. Woolfolk was able to control the actions of Miss Hardy, we wouldn't be here. Isn't that reasonable?
Well, and Your Honor, what I was saying is that Miss Woolfolk, I believe, contacted the police not because she was in fear for her own safety. She was in fear for her daughter's safety because her daughter has had a prior issue of attempting to harm herself. That is my understanding of the allegations, that in this case, the dispute between the two, my client contacted the police not to protect herself, but to make sure that her daughter was, the authorities to assist in making sure that the episode did not result in harm to her daughter. And that is what I believe Ms. Woolfolk would proffer to the court. That is solely my main concern here, and that's Ms. Woolfolk's main concern.
Okay.
Yeah. So, I understand that, the mental health courts are great. They have, I've had extensive experience. I served as drug court and mental health defense attorney when I was a public defender. They're great programs. But the lack of one, and the concern that I have is in between the time I'm going to be able to get traction on a Friday with the solicitor's office, where's my client going to go back and to make sure that we can get that no contact order addressed before she has to go to her doctor's appointment in 2 weeks. That's my main concern, because the time frame here. And again, I think that that's my concern. So Ms. Woolfolk, if I may call Ms. Woolfolk to testify.
Yes.
Ms. Woolfolk, would you please unmute and turn your video on, please?
Yes, can you hear me?
Yes.
We can hear you, but we're going to need to see you also.
Okay. It's a little slow.
And while we're waiting for that, Mr. Brill, would you ask of Ms. Woolfolk whether she's the guardian of the person and the finances, or if she's just the guardian of the finances?
Ms. Woolfolk, your power of attorney is for Ms. Hardy's financial, or is it because, are you technically the guardian of Ms. Hardy?
I'm the guardian of whatever decisions that needs to be made for her.
Understood. Hang on.
Okay,
1 second.
I'm just going to, instead of wasting time on this, we'll just keep, you can go ahead and question her.
Okay. I was trying to pull up the durable power of attorney. Miss Woolfolk, thank you for achieving. Can you tell me, can you state your name for the record and where do you currently reside?
My name is Yolanda Woolfolk, and I presently reside at 1967 Cornell Way, Morrow, Georgia, 30260.
Can you explain your relationship with Whitney Hardy to the court?
Whitney Hardy is my daughter.
Okay.
She's
go ahead.
34 years old, and we've been living here. I'm sorry. We've been living in our present residence for 21 years.
Understood. My understanding is you are the victim in a case where Miss Hardy is alleged to have knocked you over. Is that correct?
No, my daughter did knock me over. She was in an episode and she was trying to get away from me, and things just, the furniture, everything was just in the way. I don't know what she experiences when she's going through those episodes, but she was not trying to hurt me or anything. She was trying to get away.
Okay. Ma'am, you have been assisting Ms. Hardy in obtaining mental health treatment. Is that correct?
I have.
And is it correct that you provide transportation for Ms. Hardy to those evaluations? I think we're frozen, unfortunately,
Yeah,
Your Honor.
I think you're right. Okay. All right, we got you
Okay, I
back, it
can
looks
hear.
like.
Okay.
Okay.
Ms. Wilford, do you provide transportation for Ms. Hardy to her doctor's appointments?
Yes, I do.
And are you concerned for your safety if Ms. Hardy is allowed to maintain residence with you as she has been?
No, I'm not concerned about my safety because she has never harmed me. I'm concerned about her safety. And when she makes contact with the police, that they understand what's going on with her
Understood. And is there currently
concerning her mental condition.
sure. And is to your knowledge, has Ms. Hardy been taking her medication as prescribed by her mental health providers?
Yes, she has. She's totally compliant. And I witness her dosages when she takes her dosages.
Okay. Your Honor, I don't have any additional questions for my client. If the court wants to ask any questions, or this is not my client, I don't have any questions for Ms. Wilford.
Of the witness. Ms. Wilford, are you familiar with the 1013 process?
I am.
Is there a reason that that process wasn't put in place on June 6th when this happened? Uh-oh.
I don't know why Officer Angeles did not put that in his report, because I distinctively told him what the background of my daughter. I gave him the background of my daughter, and his report did not reflect what I discussed with him at my home.
Okay. So that's something that's going to have to get taken care of later. I can't address that today in a one-sided hearing.
And Your Honor, the allegations I've been negotiating with, it's just the provision in the bond amount. I understand the court's ruling. It's the no contact provision that is that we are asking to be changed to no violent contact.
And I explain why that's not an option today.
So my understanding is if I can get in touch with anybody at the solicitor's office and they consent to a bond, would we be able to have that bond condition presented before the court today?
They do it all the time. Yes, sir.
And that consent order is strictly based on their approval or disapproval?
Yes. And the reason I say that is because their situations go both ways, where their office is bombarded by the alleged victim saying, I'm now getting phone calls from this person, and why didn't you put a stay away provision on it? And we get caught up in the situation where, and it's one of the situations this week. Girlfriend had boyfriend arrested on Tuesday. Girlfriend is there to bond boyfriend out on Wednesday. So I can't make those value judgments not having the opportunity to hear both sides, because I can ask the officer if this was a hearing with the officer there. Because it says in the warrant that she said her daughter was having an episode. And the problem is, like, everybody's not trained on how to deal with mental illness. And so it may have been a situation where the officer says, hey, she was crying. It says you had a cut on your finger, says you had bruises, says your daughter attacked you in the kitchen. That's what's in the warrant for the battery. And I hear what you're saying here today, that that didn't happen. That creates the nexus for a hearing.
And Your Honor, I understand every piece of this. I understand the charge of the allegation, but a no contact order prevents my client from obtaining mental health services. That's the bottom line. That's what it's going to take. If I cannot get,
it does not. I disagree with you. It does not. You're telling me that there can't be an Uber ride to the mental health facility. You're telling me that she can't go to the mental health facility and be inpatient.
in terms of her, because she already has a scheduled appointment on the 13th. In terms of she's not having an episode, she's fully competent and fine and has been since this allegation for a month now. A no contact provision, she's going to have at least almost 2 weeks of being completely on her own, away from her, the person who has power of attorney over her. And unless I can get somebody on the phone, which has been extremely difficult. And I'm afraid that you're going to see her again if she's not able to get her medication, because she will not be able to go to the house. She will not be able to get in touch with her mother to put any of this in place. That is my concern. And again, I think that I don't think that's, I certainly don't think that's a reason to keep her in custody.
Let me ask you this. Let me ask you this, Mr. Brill. I'm sorry for cutting you off. Was there a no contact provision in place on June 6th of this year?
No, absolutely.
Okay,
not.
so the no contact provision does not have anything to do with what you're arguing. I hear what you're saying about how it could be easier. And I'm sorry that I cannot make it easier. I've explained 3 different ways how I cannot put a no violent contact provision on.
I absolutely understand. We will have my client, engage my client in posting a bond, and I will reach out, hopefully, to speak with the solicitor's office, and we can hope for the best, because I'm afraid that this bond order, I'm deeply afraid and concerned for my client's safety, but I understand the ruling of the court.
Thank you. And I'm concerned about Ms. Wilfork's safety. I'm sorry. Is there anything else, Mr. Brill?
Not at this time, Judge.
Okay, thank you. You're free to go.
Thank you, Your Honor. Have a nice day.
Ms. Tolles, I don't believe we need you, but I'm going to check again.
Hello, Your Honor. Good morning.
Good morning.
You don't, Your Honor.
We do not?
No, sir.
Okay.
Everybody's good. All right. Thank you. You all have a
Thank
great
you.
weekend.
You too.
Mhm.
All right, let's switch back over to the male side for the 2 individuals you needed.
It's gonna be Mr. Watt and Mr. Smith.
Okay.
We're gonna have Mr. Watt come up first.
Okay.
Move that cord out of the way there.
Mr. Watts, sir, you're charged with 1 count of public indecency. The bond is set by schedule at $2,000. Do you believe you can post that bond?
Yes.
You're going to have a preliminary hearing date set for August 17th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to represent yourself?
Yes.
Okay. Do you have any questions for me, Mr. Watt? Okay, you're free to go back.
Smith. Mr. Smith.
Mr. Smith, sir, you're charged with 1 count of interference with government property, 1 count of criminal trespass, and 1 count of disorderly conduct. I've set a bond, total bond at $16,500. Do you believe you can post that bond? I'm sorry, sir. Okay. Your preliminary hearing date is going to be set for August 18th at 8:30 in the morning, because there's one of these offenses is a felony. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. All right, you do qualify, Mr. Smith. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, sir, you're free to go back.
That's it, Your Honor.
Switch back over to the lady side. Okay. Stephanie Hicks.
Appreciate it, Your Honor.
Ms. Hicks, ma'am, you've been charged with one
Come
count.
back. There you go.
Yes, sir. How you doing?
Ma'am, I'm doing well, ma'am. You've been charged with one count of theft by receiving stolen property. The bond has been set automatically at $2,000. Do you believe you can post that bond?
If I can post it, if it haven't been posted already.
Okay, there's going to be a preliminary hearing date set for August 17th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I have a question.
Yes, ma'am.
With the theft by receiving stolen property, I don't really understand how I'm being charged with that.
Okay, so the allegation, ma'am, is that you were occupying a stolen vehicle.
But it came from a dealership, so I'm kind of confused and I didn't lease the vehicle. So I'm trying to figure out how was I being charged with that? And I didn't lease it or anything like that. And he said he didn't press any charges.
From what is written here, it's saying that the vehicle apparently was not returned before the dealership closed.
Right, but the thing about it is,
Your Honor, if any questions, I'll answer for him.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
no. Is
Okay.
it possible for me to sign myself out if I'm not already burned out?
No,
Why not?
because I said no. All right, you're free to go back, ma'am.
Well, I'll talk to you.
You said what now?
I'll talk to you later.
Ms. Hill.
Where's Ms. Hill?
Ma'am, you're charged with driving a vehicle without a valid license. The bond is automatically set at $1,000. Do you believe you can post that bond?
Yes.
There's going to be a preliminary hearing date set for August 17th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Jones. Ms. Jones, you've been charged with one count of making a harassing phone call. The bond is going to be set at $2,000. Do you believe you can post that bond?
Is that like a 10% or is it just 2,000 cash?
Nope. You can do 2,000 cash. You can do the 10%. You can do property.
Okay, yes, sir.
Okay. There's going to be a stay away provision on this, a stay away from Cynthia Brooks. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for August 17th at 8:30 in the morning. But that date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Absolutely. Yes, sir, please.
Okay. Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Have a great day. Thank you. Go out.
Who do we have next?
Ms. Lewis.
Okay. Ms. Lewis, ma'am, you're charged with one count of being a fugitive from justice. And this is a slightly different situation. The same rights and privileges apply to you as I mentioned earlier. However, you're being held here for a warrant out of Jacksonville, Florida for a conspiracy to traffic in cocaine. And they've indicated that they will extradite. You can waive that a right to an extradition hearing, or you can demand an extradition hearing. If you demand, yes, ma'am.
I don't understand that. Like, I'm trying to understand what's gonna be like easiest process for me because I have a job and I have, a whole life outside of this and I had no clue about this at all. So I didn't even know I was a fugitive. So
Okay. Okay, let me try to explain. So most often, the fastest way to get back and deal with this is to waive the extradition hearing, and that starts the process where they have to come and get you. Um, I also tell people that from like what you're just saying to me now, you may want to hire a lawyer in Jacksonville, Florida. Duval County Sheriff's Department is where the warrant originated out of, and the lawyer can represent you down there. Because we don't do anything up here. We don't determine whether you're guilty or innocent. All we determine is whether you're the person named in the warrant and whether the warrant is valid. Those are the only two things that we determine at the extradition hearing.
my question is, if I did decide to stay here, would it be, if I did decide to stay here, I would see a judge and then would he be able to lower my bond? Because
No,
they told me I had a bond.
you don't have a bond. You're not going to get a bond from Clayton County. The only place that you can get a bond from is Duval County.
So they said there was one there, so I need my family to work out there. Is that what you're saying? Because there is a warrant bond there, so I need to be, nothing is in Georgia. I need to be making sure my family's working on that there.
All we're doing is basically holding you. So if you made arrangements down there and everything is taken care of, they'll contact the sheriff's office here and tell them to let you go.
Okay.
Okay. Any other questions?
No.
Do you know what you want to do?
Yeah, if you feel like it's the quickest way to do it, just to go out there and handle it, then that's what I'm gonna do. Because I need this handled.
Okay. All right, ma'am. Well, you can sign that waiver and then they'll send it to me and the clock will start ticking today. But also you should, through your family, hire a lawyer in Florida to handle this. Okay.
Okay.
All right. You're free to go back, ma'am. All right. Ms. Sandifer's OTB.
This is Miss Sparkle.
Yep. Oh, this is Miss. Hi, ma'am. You're charged with 1 count of theft by shoplifting and 1 count of theft by taking. You're going to have a total bond set at $4,000. Do you believe you can post that bond?
Yes.
There's going to be a preliminary hearing date set for August 17th at 8:30 in the morning. That date will get waived upon bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes. And
Okay.
I also have one question.
Hold on. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. And what was your question?
So if I can't post the bond, if I'm able to do time served, how much time would that be?
I have no idea. That's the solicitor's office who will make that determination. Okay, the prosecutor. I'm just the judge, just setting a bond, getting you a lawyer, telling you what you're charged with. Your case will go to another court that will actually deal with whether you're guilty or innocent. Okay. Anything else? Okay, ma'am, you're free to go back.
Okay. So
Judge Gardner, that concludes the women's side.
Thank you. Let's switch over to the male. Mr. Bowman? I'm sorry, what's your name, sir?
Garcia.
I can't hear you.
Last name's Garcia.
Garcia. Okay. Mr. Garcia, you're charged with 3 counts, of theft by deception. Bond has been set for this by schedule at $2,000 a piece. So that's a total bond of $6,000. Do you believe you can post this bond?
Yes, Your Honor.
Your preliminary hearing date is going to be set for August, let's see, August 17th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you.
Lewis.
Do you have any questions of me?
No, Your Honor. Lewis.
Okay, you're free to go back.
Mr. Bowman? Good morning, Your Honor.
Good morning, Mr. Bowman, sir. You're charged with one count of driving a vehicle with the improper tint, and one count, it looks like they're saying that you were possessing a pill of oxycodone. You're gonna have a total bond set at $3,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is gonna be set for August 18th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Any questions? Oh, I can pay 10% or the whole amount, right?
Yes, yes, sir. Any other questions?
I don't have any questions. Thank you, sir.
Okay, you're free to go back. Mr. Callahan, sir, you're charged with one count of aggravated stalking. I cannot set bond for this offense at this stage. I have set a preliminary hearing date for August 18th, and I've set a bond hearing date for August 20th. Both of these are at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Oh.
Okay, sir, you're free to go back.
Mr. Bryson?
Sir, you're charged with one count of driving a vehicle without a valid license, one count of theft by receiving stolen property, being a vehicle, and one count of contributing to the delinquency or deprivation of a minor. I've set a total bond at $26,000. Do you believe you can post that bond?
Yes. I'm sorry. You said 26,000?
Yes, sir.
I would.
20,000 for the vehicle, 1,000 for the license, and 5,000 for contributing to the delinquency or deprivation of a minor.
All right, sir. Can I say something?
Give me 1 second, and I'll let you say whatever you want to say. Your bond hearing date, I'm sorry, preliminary hearing date is going to be set for August 18th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay. Huh. I don't have a form for you.
I have the Lewis form right here, Your Honor. I'll send it to you whenever we're finished.
Okay. Are you currently working, sir?
No.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, what was your question?
I had something to say. I wasn't given illegal stuff to kids. I was the only person.
The allegation in your warrant was that they were out past curfew. Okay. Anything else, sir? Okay, you're free to go back. I'm sorry?
What does that mean? This is my first time getting in trouble, so I don't know what y'all talking about.
I'll explain it to you.
All right.
Okay. All right. Thank you.
What was his bond, Your Honor?
Total bond, 26,000.
Okay. Mr. Lewis? And I had Mr. Lewis's form as well, Your Honor. I'll send it to you after the hearing.
Okay. Mr. Lewis, sir, you're charged with one count of battery, one count of use or possession of drug-related objects, and one count of criminal trespass. I've set a total bond at $9,500. Do you believe you can post that bond?
No, sir.
There's going to be a stay away provision on the bond to stay away from a Catherine Spencer. Do you understand that? Your preliminary hearing date is going to be set for August 17th at 8:30 in the morning, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working?
No, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Lewis?
I'm already out on bail, but I just figured I might as well let that be known. You gave me bail last time.
Mm-hmm.
got out on bail. And, I just wanted to let that be known, just so it's no discrepancies or anything.
No, I understand that. And that you should just be aware that at some point, the prosecutor may make a motion to have the first bond revoked because of this new offense. Okay. All right, you're free to go back, sir.
Yeah, what's your name? Mr. Lamontos?
So you're charged with one count of simple battery. I've set the bond at $2,000. Do you believe you can post that bond? I'm sorry.
Yes, sir.
You're going to have a preliminary hearing date set for August 17th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back.
Mr. Wynn?
Mr. Nguyen, sir, you're charged with one count of burglary, one count of criminal damage to property, and a second degree, and one count of entering an automobile. I'm denying bond on all of these offenses at this time, but I'm setting a preliminary hearing date for August 18th at 8:30 in the morning. I'm also setting a bond hearing date for August 20th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me, Mr. Nguyen? Okay, sir, you're free to go back.
Mr. Agoji?
Okay, sir, you're charged with one count of trafficking in marijuana. I cannot set bond for this offense at this stage. I'm setting a preliminary hearing date for August 18th at 8:30 in the morning. I'm also setting a bond hearing date for August 20th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, I'd like to hire a lawyer. Is there any, yeah, I'd like to hire a lawyer too. Is there any way the lawyer would be able to get me a bond or no?
It's possible. They would have to speak to the district attorney's office.
Okay, and it's because it's a felony, that's why?
No, it's anything over 10 pounds of marijuana. I cannot set bond at the first appearance. It's just by statute. I cannot do that.
Is there anything else I can do to get it? Wait, I've never had a criminal background before, please.
So, unfortunately, I see a lot of people in your position. I don't know what's going on. I don't know who's getting these people to do this, but can't set bond. And so I have people that this is their first arrest or they got one other misdemeanor arrest and they have to sit in jail. I mean, it's you can hire a lawyer and then have the lawyer to try to work with the district attorney's office. I can appoint a lawyer now and you can still hire a lawyer later. Okay. So do you want me to appoint a lawyer? Yes.
Yes, sir.
Okay. All right. I'm appointing a lawyer.
There's no way I could get out anyway sooner.
Okay. I'll explain it one more time.
I'm sorry. Yeah, I'm just.
No. It's fine. It's fine. You are in a position where until your bond hearing date, the only way you're going to get out is that if you have a lawyer that sits down with the district attorney's office and says, hey, this is about my client. I'm trying to get a consent bond. They may agree to it. And if they do, they'll present an order before a judge and the judge will sign it. But those are the steps. I mean, it's because if this was 9 pounds, I could set a bond. I can't set a bond for 39 pounds.
They said that it wasn't that much.
I mean, compared to what I've seen, it really isn't that much. But anything over 10 pounds, I cannot. So it could be 10 pounds, 5 ounces. I cannot set a bond.
Is there anything else I can do?
You can do the things that I told you. That's all I know of. Okay. All right, sir, you're free to go back.
Mr. Waldrop?
Mr. Waldrop, have you appeared before me?
No, sir.
Okay. You charged with 1 count of theft by taking, 1 count of criminal damage to property in the 2nd degree, and 1 count of criminal trespass. I'm setting a total bond of $40,000. Do you believe you can post that bond?
And that would be 10% of that too?
Yes, sir.
How much would that be?
It'll be about $4,000.
Possibly. I mean, I might be able to.
Okay. You're gonna have a preliminary hearing date set for August 18th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Waldrop. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, but that's, my bond still be set, I can still bond out right now, right?
Yes, it'll be set today. Okay. All right, sir, you're free to go back.
My bad.
Give me 1 second, Deputy Cox.